Good afternoon. I'm Bren Cuny, Manager of Member Services with the Ohio Restaurant Association. It's my pleasure to welcome you to Responsible Alcohol Service. As you know, the ORA Restaurant Education Series provides members free access to educational events that help them sustain and grow their businesses and are developed based on member feedback. RES events support a key ORA initiative, the education of our members. All educational events are posted on the ORA website, ohiorestaurant.org. To find past events, go to the Education and Events tab, then Restaurant Education Series tab. This is also where this webinar recording, along with the slides, will be posted in the next 2 to 3 business days. Heartland Payment Systems and United Healthcare are sponsors of all RES events. We want to thank them for their support of this valuable programming. Before we get started, I want to review a few housekeeping items and let you know how you can participate in today's webinar. We'll take your questions during the webinar, and I'll show you how to do that momentarily. After the webinar ends, a survey will pop up. It'll take you 3 to 5 minutes to complete. Please respond to the survey in order for us to improve our restaurant education series. We want to make sure that we're offering you education you find valuable. Before we get started, I want to show you how you can participate in today's webinar. We're looking at an example of the GoToWebinar attendee interface, which is made up of 2 parts. The view window on the left, which allows you to see everything we'll show you, and the control panel on the right. Within that control panel is how you can participate in today's event. So let's look at that. By clicking the orange arrow, you can open and close your control panel. From the View menu, you can also set the control panel not to auto-hide when inactive if you prefer to always keep it open. The audio pane provides audio information. By default, you've joined the webinar via mic and speakers. Click Audio Setup to select your computer speaker or headset devices. If you prefer, you can join the audio via telephone by selecting Use Telephone, and the dial-in information will be displayed, including an audio pin. As I mentioned, we'll answer your questions. Please send your questions to our webinar staff through the questions box. Simply type in your question and click Send. If you're having any issues with the webinar, this is where you're going to want to send those issues. We also have the slides posted on the control panel under our Handouts key. You can download them at any time. So here are your speakers. Today we'll learn more about the legal ramifications of not serving safely, insurance issues you may come up against, more about ServSafe Alcohol training, but we're here to answer your questions. So feel free to post questions at any time. Before we get started, we'd like to see who's on the call. Our first poll question I will post is, what is your position in your company? And if you have more than one role, please choose your main role. Give you just a couple more minutes, or a couple more seconds rather, to vote. So we can see here that 43% of you are managers and 57% of you are human resources professionals. And I have one more question before we get into the meat of the program is, have you experienced any liquor violations? And this will be helpful, especially to Gary, who is our very first speaker. Give you a couple more seconds to vote. I'm going to close it. So it looks like 43% of you have had issues with liquor violations and 57% have not. So that's a good information for us to know. So Gary's our first speaker. I'd like to tell you a little bit about him before he starts. Gary received his undergraduate degree from Vanderbilt University and his JD from the Ohio State University Law School. He's been practicing for 30 years. He has worked in several law firms over a period of 25 years before opening his own practice in 2010. The focus of his practice has been on assisting businesses that have liquor permits, including restaurants, bars, and convenience stores. Gary has represented parties in the purchase and sale of businesses, liquor licensing and renewal matters, sales tax and audit matters, and liquor citations. His practice has also involved handling many different kinds of business matters, including formation of businesses and reviewing and drafting of leases. Gary is a member of the Ohio Restaurant Association and the Ohio Business Brokers Association. Welcome, Gary.
Hello, good afternoon. The two prime concerns with safe serving of alcohol are, one, serving alcohol to underage persons, and two, serving alcohol to an intoxicated individual. Both of these actions are violations of Ohio liquor laws and can result in citations to the restaurant, bar, or other permit holder. Under the statute, Revised Code 4301.22, no permit holder shall sell or furnish alcohol to any person under 21 years of age. If issued a citation for selling or furnishing alcohol to any person, an investigator will deliver a document titled Violation Notice to the permit holder. This is and I believe the copy that we're providing is the citation. Oops, there we are. The entity that might be doing investigation can be either the state of Ohio or it could be the local police department. The violation notice provided in the seminar and all other documents I provided arise out of the same, well, not all of them, but I have two situations I'm going to discuss, and the documents that I provided arise out of one of those two situations, and I'll indicate which one was for which. The purpose of the violation notice is to put the permit holder on notice of the violation. No date for the hearing is set on that notice. That will be done later. The next thing that the permit holder will receive is a questionnaire from the Attorney General's office asking if the permit holder is contesting the charges and the number of witnesses they want to call at the hearing, and I think we have a copy of that for you as well. That's the next one. Yep, there it is. If you want to use an attorney for the citation hearing, then you'll want to send the questionnaire to your attorney so that he or she can assist you in filling it out and file it for you. This will make certain that the attorney is also notified of the hearing date when it's set. All hearings are currently held at the offices of the Liquor Control Commission on the 19th floor at 77 South High Street in downtown Columbus, and I've provided an example of a notice for a hearing date. Yes. All the hearings are set to begin at 9 a.m. You'll want to get there early to talk to the Assistant Attorney Generals, to let them know your intentions on the case, whether you're going to be contesting anything, and whether you're going to simply stipulate to the facts and then seek mitigation. The proceedings are more informal than a court proceeding. Most of the permit holders are not contesting the citations and just trying to convince the Commission that they take the citation seriously, desire to fully comply with Ohio liquor laws, and have policies in place to avoid future violations. As to the policies, the Commission expects you to make sure all employees are trained or are going to be trained, and that you have a policy of terminating offenders. The Commission seems to accept a policy of allowing an employee one mistake for sale to underage person and termination on the second violation. I know some employers have a single violation termination rule that they will violate, and they will terminate employees on the first violation. But that is, the commission really doesn't insist on that. The commission can issue a fine called a forfeiture by the commission, suspension of a license or revocation of a license. Generally, if the commission feels that the violations were intentional, then it's possible you could be looking at revocation. Generally, or at least when, I should say, the permit holder is intentional. If an employee commits it and the employer has procedures in place and policies in place, the commission generally looks to forfeitures rather than revocation. The commission is permitted to issue a penalty or forfeiture in lieu of suspension, which is at revised code 4301.252. This means the commission can set a certain number of days for the suspension and a certain fine and allow the permit holder to pay the fine to avoid the suspension. There's no restriction as to how far back the commission can look in making their decision as to the nature of the penalty. However, the statute at 4301.252 does provide certain restrictions on the penalty imposed for serving alcohol to an underage person. If the permit holder has no other violation within 2 years prior to that violation, then the penalty is to be between $100 and $200 for each day of the suspension. If the permit holder has one violation within 2 years prior to the violation, in other words, a second violation, the fine is to be between $200 and $400 for each day of the suspension. If the permit holder has had more than 2 violations within 2 years prior to that violation, which would make it the third or more violation, the fine is to be not less than $500 for each day of suspension. Fortunately, there's no limit on the number of days for suspension, so that basically allows the commission to impose almost any fine they want. The commission tends to double the fine for each violation. For example, say $600 for the first, which would be 3 days of suspension at $200 a day, or $100 a day for 6 days of suspension, or $1,200 for a second and $2,400 for a third. So in each of those cases, what they would be doing is coming up with what their penalty is per day, ranging from the $100 to $200 up to $500 a day, and then determining how many days of suspension and multiplying that out. Another factor is the age of the person who purchases the alcohol, which is usually a confidential informant. The commission has a policy of imposing a higher penalty when a person buying the alcohol is 18, and a lower penalty if the buyer is 20 years old. The photo that I provided is that of a confidential informant who I believe was 18. That got put at the beginning. There he is. And I brought a copy of that photo to the hearing to plead my client's case in trying to show that this guy looked quite old and that it was sort of unfair that they used this guy in the first place. And in this particular case, which is the second one that I was saying that I was going to talk about, he was sent back to the same location 7 times over a period of several months. Typically, when the state is doing violations, they'll come in with a confidential informant, they will obtain basically a violation. In other words, they'll bring a confidential informant in, they'll try to make a buy. If they're successful, then they will sometimes even arrest the clerk right then, right afterwards. Arrest or simply issue a criminal citation against the clerk. And then they will notify shortly thereafter the permit holder about the violation, bringing the notice in or mailing the notice in, and not do a second attempt for another month or so after they've already notified the permit holder. But in this particular case, there was a in the police department, I guess they had decided that they were going after certain permit holders that they wanted to get rid of. At least that's my belief as to why they picked my client, and went out there and brought this guy in 7 times within several months and only notified the permit holder about this after the 7th time. When it went to, there were 2 clerks involved in this one, and one of the clerks, it was purchased, the confidential informant involved 6 times with the one clerk and 1 time with the other clerk. They eventually brought criminal charges against both clerks, and the prosecutor, and I was not involved in the criminal side of this, the prosecutor agreed to drop 4 of the criminal charges against the one clerk if he agreed to go forward, plead guilty to 2 of them, and on the other clerk there was just the 1 criminal citation. The importance of me bringing up the number of criminal charges that he agreed to was that the Attorney General has a policy of only agreeing to drop the charges that were dismissed in the criminal matter. So essentially, they insisted on going forward with 3 violations on this in front of the commission, even though the permit holder was never told about the charges until after all 7 were done, and therefore you would think, in fairness, because they didn't notify the permit holder, that the permit holder should have only faced 1 charge, since it's essentially the identical charge. And so what essentially happened was, whether they agreed to do treated, and the AG then dismissed 4 and went forward on 3. It's not really entirely clear whether they treated this, whether the commission treated it as 3 separate citations for purposes of fines, or whether they treated it as 2 different ones, because they don't really break down, at least on their, when they issued the report, they don't break it out by, in this circumstance where there's multiple violations, they didn't break out which one was for which. So it's unclear if this was $2,500 for the first, $5,000 for the second, and then $10,000 for the third. But the fine on this was $15,000. The suspension was 30 days, which comes to $500 a day. The decisions are not announced at the hearing. They are sent out within about 10 days afterwards. Although permit holders are not always cited for selling and furnishing alcohol to an underage, are always cited for selling and furnishing alcohol as 2 separate citations, the permit holder should only be found guilty for one of those citations. So the Assistant Attorney General will always agree to drop one of them, and they will always pretend as though they are magnanimous in agreeing to drop one of these citations, even though they are not permitted to even go forward on it. But that is sort of typical to cite both aspects of it in the beginning, or to cite both aspects of it, because conceivably somebody could challenge the furnishing and then they would go forward on the selling. But at the time that they go in front of the commission, if you are stipulating, they will always dismiss one and go forward on the other. There's no set standard as to when the commission will impose revocation, but again, as I indicated before, if there's no evidence that the permit holder knew about the problems and that the issues were intentional, it's unlikely to be a revocation. It's not also unclear as to how many citations you would be issued, say, for underage before the commission would actually revoke a permit. I do know that, for 3 citations within a 2-year period, they won't issue a revocation. They're going to issue a fine. And as you saw, that particular client that had 15,000, I think, had more than had other violations before, so it was not the first. Those 3 were not necessarily even the first within the 2-year period. An order issuing the penalty will come within 2 weeks after the hearing. You will have 21 days to pay the fine. If not paid on time, the restaurant will be suspended from selling alcohol over, and I should have said that, a bar, restaurant, or convenience store will be suspended for selling alcohol over the specific days listed in the order. It will always be set up so the suspension occurs over a weekend. So if you had even if you had like a 3-day suspension, they're always going to do it like Friday, Saturday, Sunday to make it as painful as possible. It is best to lock up the alcohol during the suspension so no employees mistakenly sell alcohol. The copy of the order I provided was the violation within 2 years, but involved an 18-year-old confidential informant. This is the other one, first one I was talking about. The suspension period was 10 days, so the fine amounted to $150 a day for a total of $1,500, which is in compliance with the statute. You can appeal a decision of the commission on a citation to the common pleas court, but it is rare that any appeal is filed because you really can't challenge the fine, the amount of the fines. Generally, there are exceptions, but not really dealing with underage sales, at least in terms of the amount of the fine. It is important for employees to know that the person who committed the violation for underage sales may also be arrested and charged with the crime of selling alcohol to a person who is underage. They can be arrested and booked. The criminal charge does not necessarily affect the administrative citation. The citation can go forward even if the criminal charge is not resolved. However, a finding of guilt in the criminal case can be evidence in front of the commission. There are other ways that you can end up with a citation other than a confidential informant. So just because your employee is convinced that, or they say they know the person, so they know they're underage, but they're going to, and they know the person, so they know they're not a confidential informant, and so they go ahead and sell. There was a, for example, I had seen it was a NBC, I think it was, yeah, NBC news station had issued a report on the internet, news report, about a instance where a underage driver was arrested for driving while intoxicated. So he was under 21. He was arrested for that. They were then able to trace where the person bought their alcohol that day. It was two different locations. It was a restaurant and a Speedway gas station. And so they then issued citations against the two locations. And they also indicated that they were going to continue their investigation to see if they could track down which clerk sold it, so they could then file criminal charges against the clerk and maybe bartender or waiter or waitress, and file criminal charges against them. The second issue I'm going to talk about concerns sale to an intoxicated person. And this can be of greater concern to a restaurant than sale to an underage person, as it poses the risk of a citation for liquor law violation, criminal prosecution of the employee, and potential civil liability under the statute at 4399.18, which is referred to as the Dram Shop Act. Under that statute, the restaurant can be liable if an employee serves alcohol to an intoxicated person, which then causes injury either on the premises or off the premises, such as if a drunk patron drives off and gets in an auto accident. The grounds for liability under the statute are different for an injury occurring on the premises from injury occurring off the premises. If on the premises, the plaintiff need only prove that the injury was caused by the negligence of the employee or permit holder. If the injury occurred off the premises, the plaintiff must prove that the employee was aware that the person they were serving was intoxicated and that the sale to the intoxicated person caused the injury. In other words, if the restaurant had not sold the alcohol to the intoxicated person, the accident would not have occurred. While cases under the Dram Shop Act may be difficult to prove, they are very expensive to defend, and the exposure can be enormous. All restaurants should have Dram Shop protection in their insurance policy so that they have an insurance company defending that claim, and they aren't don't end up having to pay for that defense themselves. Insurance, however, doesn't necessarily resolve all the problems that you may face by having such a claim. Again, you face the problem of going before the Liquor Commission on the citation, and I had a client recently. I wasn't representing him on the Dram Shop Act. He came to me afterwards because the family, this was an accident that involved a drunk driver who had left a restaurant that was a restaurant/bar, and the family felt that the restaurant acted in, I don't know if they believed it was intentional, but at least they were extremely upset and weren't satisfied with simply getting money from the insurance company, and as part of the agreement insisted that the owner of the permit sell the business. And so my actually, it was two things. One is they actually insisted that they terminate their liquor permit and that they sell the business. And so I ended up coming in and helping them sell the business to somebody else and get a new liquor permit in so that they could operate. In that particular case, they were sort of lucky because they qualified for a permit that was not a quota permit, so they didn't have to buy a permit from somebody. They just had to prove that they fit within the qualifications, which they had already done once before. So it wasn't hard to do, but they still had to pay, a couple $1,000s, I think, in attorney fees just handling the purchase and having the permit reinstated. And none of that, of course, is covered by insurance, as well as the fact that they had to sell the business. And I believe that is it for me, if there's any questions.
We don't have any questions at this time, but perhaps we'll have some at the end of the presentation. Thanks, Gary, for that. And I'd like to introduce you to your next speaker. Your next speaker is Brad Toft. Brad is a senior account executive with Restaurant Programs of America in Cincinnati. He has been an independent agent since 1992 and has specialized in covering restaurants since 2008. He's also a member of the Ohio Restaurant Association. He is ServSafe Alcohol certified and enjoys working with the ORA in various capacities, including membership development, educational events, and writing articles for A La Carte magazine. Welcome, Brad.
Thank you, Bren. Thank you, Gary. Welcome, everyone. My portion will be much more to the point and to give us more time at the end for question and answer. So first thing I'll get right into is how insurance carriers view liquor training and how the percentages of your total sales affect your overall rate. So if we can go to the next slide real quick.
Is that the right slide?
Nope. Should be the underwriting slide, number 21.
Yep, I'm on that slide.
Oh, I'm not. It's not on mine, but that's okay. Hold on here. Okay. Well, anyway, the way the carriers view server training nowadays, especially in the last year, is there is a series of boxes you have to check in regards to your server training. They used to look at those as to give you more favorable rates if you are doing said training, because in Ohio it is not a requirement. The carriers now are looking at that more closely as they will non-renew you, or in some cases direct notice of cancellation, which in insurance terms is go ahead and get your stuff and we don't want to do business anymore. You need to have that training in place now with some of the carriers, whether or not it is required by the state. So it is very important you get that training. It doesn't affect your better rates nowadays. It will affect your ability to get and maintain insurance at this point. They are looking at that way more seriously, especially in the past year. I've had to deal with 2 notices of cancellation and a handful of non-renewals just based on that server training this past year. So they're more strict on that. The liquor percentages is the next one. Most people want to know what percentage, where can I get to, what does that mean? Typically 0 to 30 is you're doing some liquor sales, but you're still basically a restaurant. 30 to 75 is the next rung of the ladder, which it's going to increase your rates. The next step up, that's more of your sports bar, more of a bar and grill type of thing. And then 75 and up is basically they're viewing you as a bar. That being said, the type of liquor being served, and when I say liquor, that encompasses everything, whether it's beer, wine, bourbon, whiskey, whatever. They all get lumped into alcohol sales as far as the insurance company goes. But the percentages nowadays are being blurred a little bit because you have more fine dining and some brew pubs where it's more of a quality over quantity type of thing. So if you have a fine dining restaurant that's doing 40 to 50% in alcohol perhaps, but the wine list dictates that they're selling $200 bottles of wine and craft beers and things like that, it's not a proper percentage. So you can sometimes get by if you are selling more quality over quantity, where that's the way things are going nowadays is more of the specialized, the bourbons and the craft beers and things like that. The days of getting a draft beer for $1.50 are not really the case anymore. So they are looking at those percentages, and some of that 30% will get up to 40 and 50 if it makes sense to the underwriter. dictated to the type of restaurant that you're looking at. So those are some of the areas that people want to understand. Anytime you get up over that 30%, though, it starts getting shaky, and they get more strict on those server training questions. But even on the server training questions, the two in particular that got direct notice, they were doing roughly 10% total liquor sales for their overall sales, and they still wanted the server training in place. So, and then if we go on to the next thing, and I will.
Actually, can I ask a question?
Yeah.
Okay.
Yes, go ahead.
Yeah. So how are those liquor percentages determined? Because how is a restaurant going to know how much alcohol they're going to sell? So
it'll be on their P&L statement. If it's a brand new restaurant,
yes,
and they don't know moving forward, I tell them to be cautiously optimistic and just estimate as best as you can. And what I would recommend is maybe 6 months into it, look at it again and see if you need to adjust your overall sales or your percentages. At that point, it's really hard to tell what your actual sales are going to be as a startup. Everybody wants to come in and says, yeah, I want to do $2 million in sales, but you might only end up doing 700 in sales. So I always tell people be cautiously optimistic, and then if it goes better than expected, paying a little bit more for your insurance at the end of the year because you did better than you anticipated is better than overpaying for your insurance during the year and be struggling because you overestimated on your overall sales, if that makes sense.
Yep. Thank you.
So you got it. So if we go back onto the claims, and I'm not going to rehash what Gary talked about, but because the very first bullet point is the most important, your liquor liability, which pertains to the dram shop laws, people going off your property, injuring, car accidents, et cetera, et cetera. That's the most common thing you're going to see on claims. The second more important one that I've had to deal with this year are assault and battery claims, which means the most common one, I had an issue with a bar. It wasn't my client, thank goodness, but they had a couple of assault and battery claims over the last couple of years. What that means is, and most people don't realize this, if two people are drinking in your bar, and let's say in this particular case, believe it or not, it was an argument over a football game. I don't know if it was Bengals and Browns, but it's irrelevant. But the two gentlemen proceeded to get into a fight and injure each other, and that goes back on the bar owner for not controlling the amount of alcohol that those two gentlemen were taking that lessened their inhibitions and got them to fight that day. They had two different examples of that over the last 3 years, and unfortunately, they maxed out on the claim. They ended up paying quite a bit of money to the gentleman that was injured in said fight, and then a second one was a more minor one. But the two claims together, nobody would insure them, and they had to go out to a non-standard market, and then financially were unable to afford insurance, and within 3 months they were closed. So it really speaks to the fact that all of these liquor-related incidents trickle down into your overall bottom line, because you need to control it from people coming and going, and also people inside your four walls as well. And those are two very real examples that I had to deal with. But because by the time they got to me, I really couldn't help them because they didn't have policies, procedures, training in place to handle situations like that. So that is all I have for my portion on the insurance.
Okay, well, we don't have any questions yet, but as you are listening to the last speaker, definitely think of some questions you might be asking us, and you can definitely ask during this time, and we can go back to Gary as well as Brad. So let's continue. Our last speaker is me, Bren Cuny. As I mentioned at the beginning of our webinar, I'm the Manager of Member Services. I've been with the Ohio Restaurant Association since June of 2012. My primary responsibilities include new member orientation, developing and implementing ORA's Restaurant Education Series, as well as leading retention efforts. I'm also the lead staff person on answering ServSafe questions from the public. I have my ServSafe Food Handler, Manager, and Alcohol certification. Before I talk a little bit about the ServSafe Alcohol program, I'm going to ask you a question. Do you have a training and certification program in place regarding alcohol? If you could go ahead and vote, we'll give you just a couple seconds. We just like to see where everyone is at. And if you're not sure, feel free to answer not sure. I'm going to close the poll now. Well, it looks like it's a 50-50 split. So half of you have some type of training program in place and some of you don't. So I'm going to go back to the presentation. As I mentioned before, both Brad and I have taken the course. The course was quite eye-opening to me. The course is very important, but even more essential is the ongoing training for your staff. And some of the policies that Brad just referenced. For example, are you making sure they card everyone who looks under 28 every time? Does your staff know what to do with if an altercation occurs between customers? And are your servers and bartenders tracking the drinks they're serving to customers to make sure they're not getting intoxicated? These are all examples of what you could learn by taking the ServSafe Alcohol course. Knowledgeable, responsible alcohol service should be a priority for every operation, and this program prepares all front-end staff house to effectively and safely handle difficult situations in your operation. So the creators of ServSafe Alcohol teamed up with experts in the beverage, food service, medical, insurance, legal, academic, and regulatory industries to develop this comprehensive program. You can trust the ServSafe Alcohol program because it was built by the same creators as the highly regarded ServSafe Food Safety program, which has been protecting the industry for nearly 40 years. So there are 4 key sections: law and your responsibility, recognizing and preventing intoxication, checking IDs, and handling difficult situations. And what operators love about the program, and what I really liked about the program, is that the training materials reflect real world experiences and practical approaches. In the online course, you actually have scenarios that you must complete correctly in order to continue the training. So what are some of the benefits of ServSafe alcohol training? Well, it's convenient. It's available on print and online. The online course is available 24/7 to accommodate the non-traditional work schedules. And if you have some staff that want to take the in-person class and others that have to take the online class, you don't have to worry about inconsistency in education. It's exactly the same. There's also, if you have Spanish-speaking staff members, we do have a bilingual service center representative that can assist you. Let's talk a little bit how long it takes. So the classroom can be taught in 2-hour increments of either 2, 4, or 6 hours, depending on the level of interaction and the review you prefer. Online, depending on you, it might take between 90 minutes and 120 minutes. Though once you purchase it, you do have 90 days to complete it, so you don't have to rush through it in just a few days. There are 2 exams you can take. The primary exam has 40 questions, and this would be the exam most people would take. The advanced exam would be those for who want to be a ServSafe alcohol instructor. It has 70 questions and it must be proctored. So maybe the general manager or the bar manager would want to take the advanced course, whereas the servers and bartenders might just want to take the primary exam. You get a 3-year national certificate once you've passed the exam. And like the other ServSafe certificates, it belongs to the staff person, not the business. But okay, so what's the cost? Because you're an ORA member, your price is discounted 15%. And for the instructors, there are instructor tools available, and there's a 5-package DVD set that you can purchase in a bundle or individually. The DVD topics are alcohol law and your responsibility, recognizing and preventing intoxication, checking IDs, handling difficult situations, and evaluating real-world scenarios. So how to order? You can go to ohiorestaurant.org and click on the ServSafe tab, and you can get to it, or you can use the red URL below, servsafe.com/ss/SRA/OH. That's how you can get that 15% discount. However, I do have great news. NRA has introduced a holiday promotion with a 30% off discount, twice the member savings, just by ordering by the end of the year. Now, that doesn't mean you have to do the course by the end of the year. It just means that you have to order the materials. I'd be remiss if I didn't mention the other levels of education that ServSafe offers. All of them are online. the manager training, which is a 5-year certification, the food handler training, which is a 3-year certification, and it's a very good certification for you and your staff to take, and the allergens training. So now is the time for question and answers. We do have one question, and I'm unmuting my colleagues so they can answer if they want to. The first one was, what is the score required to pass? So I can answer that one. The passing score for a ServSafe Alcohol primary exam is 75%, and this is obtained by, answering at least 30 questions out of 40 questions correctly. And a passing score for the ServSafe Alcohol Advanced Proctored Exam, if you want to be an instructor, is 80% or higher, which is at least 56 questions out of 70. And the online courses and the classroom courses have the same passing rate. So do we have any other questions? Haven't received any, so I'd love to get a few. Okay, well, it seems like we may have answered everyone's questions. So I want to thank you, Gary and Brad, for your wisdom and your time.
You're welcome.
Thank you.
And before we end the webinar, I want to just talk briefly about Ask ORA. So recently, the ORA rebranded our information resources to Ask ORA. Have a question? We'll help you find the answer. Ask ORA is the trusted source for Ohio food service industry information, recommendations, and best practices. Document and article topics include running your business, working with your government agencies, developing your workforce, and much more. Through Ask ORA, the ORA staff serves as an extension of your team. We find the answers you're seeking on matters important to your food service business, whether it be music licensing, food safety, city, county, state, and federal requirements, social media, marketing, or HR. You ask, we'll answer. So we are done with the restaurant education series for 2015, but definitely go back to ohiorestaurant.org to check out past RES webinars you may have missed. Also, we have some great educational opportunities at NAPICS in January, and don't forget you can get free tickets to NAPICS because of your ORA membership. I want to thank our sponsors again of the Restaurant Education Series, Heartland Payment Systems and United Healthcare. Please know that the ORA exists to help you build your customer loyalty, have a rewarding career, and experience financial success. Simply put, we are here to help you win. Thank you for your participation in this webinar today and for your membership in the ORA. This ends today's webinar.